Is it Mr. Mahfood?
It is, Your Honor. I
Am I
can't hear.
doing that okay?
You are, thank you.
All right, excellent. All right. Good morning, everybody. This is an oral argument session of the Sixth District Court of Appeal. My name is Dan Traver, and I will be presiding over this session this morning. Before I announce the case and my fellow panelists, I would just like to announce that this is being streamed live over YouTube. So just please be mindful of that. I'm joined on the panel today by my colleague, Judge Carrie-Ann Wozniak. We're also really pleased to be joined today by an associate judge. This is the Honorable London Kite. Her day job is as a circuit court judge from the Fourth Judicial Circuit. She sits in Duval County. It is really through the kindness and grace of the Chief Justice of the Florida Supreme Court that we as an appellate court have been allowed to bring back what really was essentially the pre-COVID tradition of allowing our trial court brethren to serve with us. It really helps us out. We're a very busy court, and we're really pleased that she's joining us today. This case is case number 23-2559. It is Tyler Forey et al. Versus Marlin Construction Group. Mr. Mahfood, you represent the appellants. Typically speaking, we would reserve 5 minutes for rebuttal, but we can do more or less for you if you would like. What would you prefer?
5 minutes is fine, Your Honor. Thank you.
All right, you can see the clock in the upper left. I'll hop in if necessary, but whenever you're ready, sir.
Okay. May it please the court, as you've noted, I'm George Mahfood. I represent all 7 of the appellants in this matter. And this case is a perfect example of why the Florida Supreme Court has held that the imposition of attorney's fees under the inequitable conduct doctrine is rarely applicable and reserved for those extreme cases where a party acts in bad faith, vexatiously, wantonly, or for oppressive reasons, or exhibits egregious conduct, and why the court must make detailed findings describing the specific egregious conduct or bad faith conduct as to each party. Now, the position of the appellants is that none of the evidence or the findings of the lower court support the conclusion that any of the appellants have acted in bad faith, vexatiously, wantonly, or oppressive. And the court makes no findings to that effect. Very significant fact, no findings of bad faith. Interestingly, we believe that that's associated with the fact that the court, after the lower court hearing, decided to sua sponte file or submit a motion for sanctions against my clients without actual notice in advance. And the reason that no findings of bad faith were made was because the hearing in the lower court wasn't for bad faith. The hearing in the lower court was to determine whether there was fraud on the court.
Can you hear me, Mr. Mahfood?
I can, Your Honor, yes.
Okay, thank you. So I apologize if there was a technical issue. I do have a question on the due process and the notice issue, which I know is one of the main issues that you raised. What would have been satisfactory to you as far as meeting due process? Would there have had to have been another hearing, a formal notice? What would have been required as your position?
Your Honor, yesterday we submitted a notice of supplemental authority of a case decided on August 16, 2024 out of the 5th District. The name of the case is Olchik versus Parenti. It's at 2024 Westlaw 383-7061. And that case describes what should have been done in this case. If the court, as it did, decided that the evidence wasn't sufficient to meet the standards for fraud on the court, and if it wanted to sua sponte hear a motion for sanctions under the inequitable conduct doctrine, it had to give notice, and it had to set the matter for hearing, and it had to give my clients the opportunity to present evidence that would address the standards that are set forth in the Moakley case and in the Bitterman case.
That seemed different in that case was that it was in the middle of either a hearing or a trial, and the attorney's conduct, I guess, came to the point where sanctions were imposed. But here in the motion to strike, I think it was the motion to strike, in the wherefore clause, it said it was asking for reasonable attorney's fees there. So weren't your clients on notice there?
My clients were on notice with a wherefore clause that was addressed to a motion to strike for fraud on the court, which was denied. And once that motion was denied, then any attorney's fees under that motion that could be awarded were also denied.
So
Is
there
there
has
a
to, the judge would have had to say, counsel, I am giving notice that I am thinking about imposing sanctions. We're going to have another hearing on this. That's what would have been required, is your position?
Exactly. That is our position. That is what was required, Your Honor.
Is there another basis for fees contractually or statutorily in this lawsuit?
No, Your Honor. One of the things I wanted to point out is that this is a case which involves an exception to the American rule. There's no attorney's fee provision in a contract. There's no statutory provision. There's no other provision which would allow the imposition of attorney's fees.
I guess that's my point. What did you take that wherefore clause as to be putting you on notice for?
Merely that maybe, not guaranteed, maybe if the court found that the case, the pleading should be stricken for meeting the standards for proving fraud on the court, then the court could consider attorney's fees. Not
under the basis of the inequitable conduct doctrine, right? Because there would have been no other.
Actually, no, Your Honor. Well, on the basis.
Then help me with that, because to me it seems like if you've got no contractual basis and you've got no statutory basis, and there's a request in the wherefore clause for fees, you're being put on notice of something. And I can understand the argument maybe a little bit better if there were a contractual or a statutory basis that you're making. But what do you think that you were being put on notice of?
My clients believed and their trial counsel believed that they were being put on notice of a hearing for a motion to strike pleadings for fraud on the court. In none of the papers that were submitted to the trial court, other than that offhand comment in the wherefore clause, did anyone address the subject of fees. The motion itself did not address the subject of fees. The response did not address the subject of fees, and the hearing did not address the subject of fees. So you could imagine that my clients were quite surprised to see at an order that said, oh, by the way, I'm doing a motion to sua sponte motion to impose fees for sanctions.
So circling back to Judge Wozniak's initial question, should every trial court, for example, have to put in its notice of hearing that if attorneys or parties fall below the Moakley and Billingsley standard that they can expect to be sanctioned for bad faith? Or is it something, and I understand this almost to be a 1A or a backup argument for you, if the court decides to do that, then it just has to convene a separate hearing as it relates to whatever evidence or testimony might be put into play as it relates to the discrete issue of bad faith?
I think a second hearing is required, Your Honor. It's only fair.
Okay, so then I understand that you're essentially saying you're making the same argument, but in two ways. Number one, even though there was this thing in the wherefore clause of a motion that was denied, we had no notice at all. And number two, even if we did have notice, we didn't have an opportunity to put on bad faith evidence.
Non-bad faith evidence, yes. We didn't
Well,
have that
sure.
evidence that there was lacking of bad faith. But
I guess I'm just grappling with that first issue because it would be really, it seems hard to me to have to give a lawyer or a party notice. And I'm not saying whether yours did or didn't for the sake of my question. So I'm not asking you to defend against that. I'm just saying, generally speaking, if we were to reverse on your first issue, it seems like we might be making every trial court put in a notice of hearing or somehow otherwise alert lawyers and parties to what they ought to know is their basic obligation. Don't fall below this lofty, egregious level of bad conduct.
Well, Your Honor, I think that position has been rejected by the Fifth DCA in the Olchik case. I really do. I don't think a party should be required to anticipate that they're going to be held to conduct a hearing, which is the point of a notice of a hearing is to muster the evidence. Muster the evidence necessary to address the standards that the court has to address to impose fees. If you're not given notice that that's what the court is going to be considering, then you will not have had the opportunity to muster the evidence, get the witnesses, prepare the witnesses, get the documents. That's what's required. And by the way, I want to stop for a moment because I don't want to run out of time and say, this is a backup argument here for us. Our argument, our primary argument is that the order imposing fees should be reversed and the imposition of sanctions should be vacated because there is insufficient evidence and there are no specific findings that the court made in compliance with the Bitterman and the Moakley case to warrant the imposition of fees. As I said when I started, this is not a case that involves the kind of conduct that is warranted. I mean, if I may, and I will let Your Honor give me, if you have more questions on that point, I'm happy to hear it, but I didn't want to let this time pass without saying, I don't think that's our primary argument. Our primary argument is it should be reversed and no rehearing should be required. If, however, you think a rehearing, there's some ambiguity or that there's something may be necessary, then a rehearing is required. But our position is the evidence here is completely insufficient and the findings are completely insufficient to warrant the imposition of sanctions under the inequitable conduct doctrine.
Sorry.
Your Honor,
Just
I
you-
couldn't hear you. I couldn't hear you just watching.
Oh, can you hear me now?
Now I can, yes.
Okay, I'm not sure what the issue is. This is maybe a harmless error type question, but what evidence would you have produced if you had gotten more notice and had another hearing? Because it seemed like a lot of the witnesses already testified in their defense to say this wasn't bad faith. Would there have been different evidence that you would have presented?
Yes, I believe it would have been presented in a different way. If Your Honors look at the record, the evidence that was presented was my clients were called by the opposing party and were asked questions on cross-examination. My clients weren't given the opportunity to consider what are the charges here and how do we deal with it? So what would the evidence have been? I'm not going to sit here and tell you that I know what evidence would have been because I didn't interview the clients for that purpose for this hearing. However, I will tell you that I've tried a lot of cases and I would have set out, okay, tell me about what your business model was like. Tell me about how you worked with your employers. Tell me what you did to allow to gain access to this database. How did you get it? What was appropriate? And by the way, I want to point out for the court, there was no evidence contradicting my client's testimony. Danielle Forey's testimony was not contradicted by anyone. And the plaintiff's lawyers could have offered evidence to contradict. They did not. However, we would have presented evidence, I'm sure, about the operations of Marlin Construction while my clients worked there. And that would have given a bigger picture for the court to determine whether my client's denials, because that's the issue here, was my client's denials of this in this answer outrageous conduct. And that would have been considered by the court, and my clients would have had an opportunity to present it in a way which wasn't simply an accusatory method by the plaintiff's lawyers. Because if you read the transcript, and there's lots of testimony here that I would like to point out for the court. If you read the transcript, it's accusatory. It's cross-examination. It is not direct examination, and it is not an opportunity to explain. So that's the difference, Your Honor. And if I might, just in the last 2 minutes before I have to yield, What I'd like to point to the court is the trial court focused on paragraphs 14, 80, and 98. My client's denials in those, and by the way, before I even get to that, the trial court agreed that all of the appellants, other than Danielle Forey, could have denied those allegations in 14, 80, and 98 of the complaint. And yet the court imposed sanctions against the other 6 appellants, with making no findings of any kind of outrageous or inequitable conduct. None. Secondly, and I want to get to the affidavit, and I'll come back to Danielle Forey. I have about a minute. With respect to the affidavits, the court actually found that Tyler Forey behaved reasonably under the circumstances. And he could not disagree, he could not find fault with the testimony of Forey. He didn't discredit Tyler Forey's testimony. And he placed fault on the notary. And so the bottom line is there are no findings of outrageous or inequitable conduct on behalf of any of the appellants with respect to the affidavits. And so I think in those alone warrant reversal. Now, with respect to the allegations that Danielle Forey denied, you cannot review paragraphs 14, 80, and 98 without reviewing and taking into consideration paragraph 13. Paragraph 13 alleged that she and Tyler and Garner, along with the other company defendants, entered into a conspiracy to defraud Marlin and to steal from Marlin through fraud, trickery, and deceit. Your Honor, I'll if I could have 4 minutes instead of 5 minutes on rebuttal. And when asked questions at the hearing, Danielle Forey testified the way that she's talking about paragraph 14, that reads to me is that it was taken with intent to steal trade secrets. And so for that reason, I said denied. It was something I needed to complete my job at Marlin. Again, another question at 2620 of the record. No, I didn't take anything. It was given to me. Paragraph or page 2624. Conspirant stole certain trade secrets for purposes of starting your own competing business. That's not true. Is that a question? Yes, ma'am. I don't agree. I didn't conspire and steal. Paragraph on page 2626. She repeats, as I said, I don't believe I took it. I believe I was given access to it. And I was allowed to have it, and I needed it to complete my job tasks for Marlin. So that is the context in which those denials were made. That is not outrageous conduct. That's fair and reasonable. I apologize, Your Honor. I'll take whatever I have remaining.
All right, sounds good. Mr. Hertz, at your convenience, sir.
Thank you, Your Honor. May it please the court. My name is Scott Hertz, and I represent the Appellee Marlin Construction Group. We're asking you to affirm the trial court's properly entered order sanctioning the defendants for their improper answers and the use of the false and fraudulent affidavits in the litigation before the trial court, which the defendants procured and used multiple times, and all of the defendants were involved in the swearing to and presentation of those affidavits. So it's not one person, as implied, and the court did not find that Mr. Forey was not responsible for what occurred. The court stated that the procurement of the affidavits was fraudulent and potentially felonious. The court, in fact, as you can see in the transcript, ordered me personally to report the notary to the governor's office and the Florida Department of Law Enforcement, which I did. The notary did end up losing her license over what occurred. It's important to understand, as set forth in the record, that Danielle Forey, Mr. Tyler Forey's wife, is a notary and was a notary at that time. Some of the questions to Mr. Forey were about, why didn't you ask your wife, Mrs. Forey, to notarize these documents? And she was involved in the process. And the court said over and over that if the standard for the striking of the pleadings had not been clear and convincing, the court would have granted it. The court over and over held up its hand and put his fingers almost all the way together and stated, was this close to doing so? And the court clearly stated, as Marlon had requested, that the
What
attorney,
did Mr. Garner do wrong?
Mr. Garner, verified the motions which submitted the affidavits and submitted them to the court. The affidavits were submitted on behalf of Mr. Garner, and Mr. Garner averred to
What
all
was
of
his role in procuring the affidavits?
I believe he did assist with one of them, Your Honor, specifically.
What was his role in responding to the allegation as it related to Mrs. Foray getting the customer list?
In not just in the answer, but in the all of the subsequent pleadings set forth in that original motion in the record, Your Honor, Mr. Garner also incorporated the false denials and false statements into his answers. If you look at the record at page.
How do I reconcile that with the trial court's determination that he should have conditionally denied that paragraph, or that Ms. Foray should have conditionally denied that paragraph? And all of this, Mr. Hertz, is geared towards the idea that I have some concern about how wide the trial court's order sweeps, and that you're sweeping in every corporation and you're sweeping in every individually named defendant in this case for conduct that, at least in one instance, seems to be exclusively perpetrated by Ms. Foray.
Yes, Your Honor. First, to clarify, if it wasn't clear from what the court reviewed, each of the LLCs other than the Roof RX LLC is a single member LLC. So the Better Roof Guy is a single member LLC owned, and the principal is Tyler Foray. The Island Life Charter is a single member LLC owned and operated by Danielle Foray, and Miles High is the sole owner and principal is Miles Garner. So one of the things that we pointed out is entities can only act through their principals, and those are the principals. Those are the principals and the entities that were involved in this matter. And all of these facts were sworn to in verified motions where each of them, Danielle Foray, Tyler Foray, Miles Garner, swore under the penalties of perjury that all of these facts were true. And you come back to this denial when you look at the substance of the email. And I think it relates to your question, Your Honor, where it was stated that there was no evidence that rebutted or contradicted Ms. Foray's testimony. If the court simply reads the email that was central at issue in the case, you can look at it in the appellant's initial brief at page 7 of their brief. On page 8, one of the key factors is they denied over and over that they used the information to solicit referrals. The email explicitly says, if you have any questions, concerns, or referrals, please do not hesitate to reach out. To contact Danielle Foray and Tyler Foray at their roofrx.net email addresses and personal telephone numbers at the new company Roof RX that they both started. And the court stated he didn't find Ms. Foray's testimony credible, that the email says what the email says, that Ms. Foray was questioned. She said in her testimony, the purpose of the email was to defend myself and my husband against these disparaging comments that were made by Marlon about them. And nowhere in the email does it talk anything about disparaging comments or setting the record straight. Mr. Foray, under oath during the hearing on this, was forced to admit he was a con artist. He was a convicted criminal for committing bank fraud and wire fraud, which is what they accused Marlon of saying he was. So the testimony that this email was written to clear their names of something that A, was true, and then B, isn't contained in the email, and then a direct denial that this email that was sent to every single contact in the Marlon customer and referral source database that asked for referrals, Mrs. Foray explicitly and directly denied that it did that, even though that's what it says. And Your Honor, this is very similar. I thought you were going to ask a question. I apologize.
I was going to try.
Go ahead.
Go ahead. I was going to say, please address your colleague's assertion that he would have adduced more evidence if given an opportunity to rebut a charge of bad faith.
Your Honor, let me address it first I'll make the point and then respond. As you brought up the wherefore clause of the motion, we consider the attorney fees to be a lesser included sanction of within the court's authority, and the wherefore clause explicitly said, use the court's inherent authority to award attorney fees. Okay, it wasn't just the generic and all other relief. It explicitly set forth based on the court's inherent authority. We referenced Moakley v. Smollett in the motion, and then in the hearing, they certainly had the full opportunity to call any witnesses they wished. Just like in a trial, Your Honor, we may have called their clients, or we may have called the defendants, I'll say, say it differently, Mrs. Forey and Mr. Forey, and have them testify. There's nothing that prevented the defense from recalling them. There's no difference when that was stated that it was a different cause of action. It's the same cause of action. The imposition of the attorney fees is for the same acts that we believe the pleading should have been struck for. So I don't see how there was anything different. I don't understand what, and nor was there anything that prevented them from eliciting any testimony from their clients that they wish. The court was quite clear that everyone would have as much time as they needed. The court continued the hearing. The court stated another full day could be made available. There was no limit on the time available to them, and they were well aware of all of the issues. There are no new issues that were raised by it, and this comes back to they're looking for magic words, Your Honor. This whole appeal is about attempting to impose a requirement that there be magic words. And Florida law is clear, as set forth in Robertson v. Ward, that there are no requirement for magic words. You don't have to have a specific word that is used in the order to set forth these allegations of the bad faith or improper conduct. And it's quite clear over and over, replete through the record as well, what the court thought of these actions. And Robinson stands for that as well, where the second DCA found that the written recitation of the bad actors' improper behavior combined with the numerous oral findings in the record provided more than adequate support for the court's decision to grant sanctions. This record is replete. I can cite for you over and over at each one of the hearings where the court stated its opinions, where the court reviewed the evidence and made these decisions. There was no surprise here. There was no gotcha. Further, unlike the Olacek case, where they specifically held that the motion for reconsideration was denied without hearing, did not provide sufficient time. In the Olacek case, it was not set for a hearing originally, the sanctions. It came up during the course of another hearing. So they said the sanctioned party wasn't given proper notice that they could be sanctioned. Then they filed a motion for a hearing, and it was denied without hearing. And the second DCA has found that didn't give them notice and opportunity to be heard. That is completely different than what occurred in this case. You originally had our motion to strike, which also requested the attorney fees under the inherent authority of the court. That was originally held on November 3rd of 2021 for 2.5 hours, Your Honor. And then again, it was continued to November 8th for another 3.25 hours. They had every opportunity to call any witnesses they wanted. They even had time in between after the hearing had started and they saw the way it was going and the questions that were going to be asked that they could have called additional hearings. But again, unlike Olacek, then the defendants filed a motion for clarification on January 28th of 2022. That motion was heard on February 14th of 2022. They had an opportunity there. And who set that hearing? The defendants. The defendants were at the hearing. It's their motion. They set it for hearing. They certainly could have set it for an evidentiary hearing and presented witnesses or evidence at their motion for clarification. But if they didn't do it there, Your Honor, they then filed a motion for reconsideration on March 7th of 2022 of the order at issue. They set that for a hearing, and it was heard on March 31st, 2022. They didn't set it as an evidentiary hearing. They only made legal arguments. They chose not to call witnesses. They chose not to present evidence. So this case is completely different than the ones cited to by the appellants in that they had every opportunity and notice of what was occurring and to be heard and to have it reheard. They had 2 hearings on rehearing it. That's on top of the other motion they filed for reconsideration that they didn't set for hearing. Then we had the extensive evidentiary hearings on the attorney fees. And that, the court will recall that the first motion they raised during the evidentiary hearing that was set that they didn't feel the order explicitly put them on notice that the defendants could be responsible or would be held responsible for the attorney fees associated with the false and fraudulent affidavits they had procured. The court said, okay, if you think you're not ready, I will continue the hearing. We will amend the order. The court said, I thought I was very clear, and I think the order is clear, but if you think it's not, we will amend the order. We will make it eminently clear that the affidavits are also at issues and that all of the defendants are responsible, and continued the hearing to 2 months later and had an evidentiary hearing on those issues. So all of these issues that are being argued here, that they're telling you they had no opportunity to present and present witnesses and evidence, they had all of those hearings and they could have done that. So I think they failed to do that, and they're looking for magic words. Your Honor, to me, this is similar to what occurred with proposals for settlement until several years ago. It had gotten to the point in Florida where proposals for settlement were almost useless. Every time there was a hearing on a proposal for settlement, the person on the losing side would say, this is ambiguous, and courts kept finding them ambiguous until finally the Supreme Court said, no, stop nitpicking proposals for settlement. If the proposal for settlement fairly puts you on notice of what's going on, and it's not so blatantly ambiguous that nobody can understand it, it should be read as intended. That's the same thing here. That's what the court said, and we cite back to Robinson v. Ward. Magic words aren't required, and they're looking for magic words. And even when they got the explicit language in the wherefore clause, they feel that's not sufficient. And the court did find that ignorance of the law is not an excuse. It's not in the order, but it is in the record. And I can cite to the court where that is if necessary. But during the arguments on this, he found that Mr. Forey did procure the false and fraudulent affidavits. Mr. Forey hired the notary who did this. It was all highly irregular. The court emphasized again over and over in the record, as we cite to in our reply, in our answer brief. I apologize, misstating there, answer brief. All of the places where the court said that. At the sanctions hearing itself on November 8th, in the record at page 2643, lines 3 to 24, the courts described the affidavits as having been illegally, if not feloniously notarized, and the process as abhorrent and highly suspect. At page 2652 in the record, the court says, well, they aren't.
Let me ask you a question about the actual award, the number at the end. And I'm going to ask you to switch gears a little bit. Just assume for me that this comes into play for us. I'd like you to address the argument raised by your colleague that the trial court misapplied Moakley in terms of talking about what was directly related to the bad faith conduct as opposed to what would be inextricably intertwined, like you would see in a typical fee application. It seems like the argument that you have to make is that if Ms. Forey had conditionally admitted to these particular paragraphs in the complaint, and that if Mr. Forey had done the appropriate things to get a good notary who would have done this the right way, that you would have saved all of that money. Do you agree with that assertion? Just address that for me if you'd be so kind.
Yes, Your Honor. I do believe it was all inextricably entwined because the allegations run through all of the complaints. We set forth that they were in 12 of the 14 causes of action. They were all interrelated. It comes back to, and again, comes back to the use of originally the database of Marlin's trade secrets with all of the contact information that Mrs. Forey used to send the email soliciting business. There was also the issue of taking contracts and other things and soliciting those folks. And that is what the affidavits were about. The false nature of the affidavits, Your Honor, were not just that they were improperly notarized, but the statements in the affidavits, particularly relating to how those affiants or purported affiants came into contact with RoofRx, were shown to be false. When those people were questioned, their testimony in their depositions and at the hearing was, that's not what happened. I didn't do it.
I guess you're getting really granular, and okay, you can do that because you know this case really well. I'm asking you to look at it from a big picture perspective. How is literally almost every dollar that your client incurred in this particular case recoverable as due to bad faith conduct of two actors.
I understand, Your Honor. And that is where the doctrine.
And I guess let me, now that I slowed down enough to let you start, and I thought of something else to ask you, I'll do that irritating thing where I interrupt. I understand how that is the inextricably intertwined test is appropriate when you're looking at counts, for example, one of which has a fee basis and one of which doesn't. To me, and maybe you address this first for me as opposed to addressing a granular detail of the case, Moakley seems to outline a different test, which talks about the bad faith conduct being directly related to the fees that were incurred. Would you address that difference for me as opposed to just getting into the facts of this case, just the legal answer?
Yes, Your Honor. The issue is that it does become inseparable, that they're all interrelated. And so from a legal standpoint, right, at what point does it become de minimis to say, okay, yep, you wrote this email for a 0.1 on this one day that's not directly related to the bad faith, and we could comb through every minute and spend, you know, thousands of dollars looking at those issues to try to do that when it's de minimis compared to what the overarching issues were. So that issue was raised, for example, in relation to the deposition of Mrs. Forey. It was talked about that that was an all-day deposition, and that it's only at the end of the deposition that this, what we call confession, came. And the court addressed that, and it's that's what happens, that you have to walk somebody through all these other things till you sort of get them to the point where they admit this, that they're not unrelated. And so that's also true for these other things. That's why we pointed out all of the times when the defendants doubled, tripled, and quadrupled down on the same assertions. It's laid out in the motion, and we pointed out to you in our answer brief how many times they reaverred these things. So we had to address it in each of the discovery responses. We had to address it in the verified motions that they filed to set aside the petition for their verified motions for an injunction, their motions, verified motions with the affidavit, the repeated false statements. They had to restate their discovery responses multiple times. And even when they restated them, their amended and second amended discovery responses contained the same false assertions. So it was truly the same conduct tracked through and was interwoven into everything we did. It wasn't separate. It wasn't separate, and it wasn't separable. I'm sorry, Judge Wozniak, I see you're trying to talk, but there's no sound. I still cannot hear you, ma'am.
Can you hear me now?
I can hear you now.
Okay, I don't know what the issue is. Didn't Marlin's fee expert, albeit on cross-examination, admit that there were depositions and discovery that needed to be done regardless of the bad faith issue? I remember seeing that in the transcript, and it seems like the trial judge just overlooked that and said that Marlin's expert was more credible.
Yes, Your Honor. I'm not going to deny that the depositions of the defendants certainly would have had to have been taken. The depositions of all the affiants would not have needed to be taken if the false affidavits hadn't been put forth. There wouldn't have been a necessity to take their depositions if the defendants had been truthful about what occurred and didn't present false information. I'm not going to deny that you would have needed to have taken the defendants' depositions, but then those depositions were focused on these denials of what occurred. Instead of them saying, yes, we did it, and here's our justification for why we did it, they denied doing it over and over and over. And that's what makes it inextricably entwined, in our opinion, Your Honor. So we're asking you to affirm the lower court to find that it did properly set it forth, that the oral pronouncements in the record, that the records were replete with at each of these hearings, and that the multiple hearings did, if there was any issue with notice and opportunity to be heard. In this case, unlike the one cited to by the appellants, there were subsequent hearings. The defendants had the opportunity to have evidentiary hearings if they had chosen to, and they would have done so. Judge Traver, I see you have another question.
No, I'm just asking you I'm asking you to wrap it up.
Oh, I was watching my time.
Yeah, you're over. All right. Thank you, Mr. Hertz.
Thank you.
Mr. Mahfood, we'll give you an extra minute.
I think the following points are determinative of issues in this appeal. Number one, in paragraph 27 of the lower court's findings, he found that the other defendants could have denied the allegations, which he said that Danielle Forey could not. So 6 of the defendants didn't do anything wrong in connection with that denial. Number 2, with respect to the affidavits, he said the defendants, the affidavits used by defendants in their proceedings may have been gained through sloppy handling and did not comply with the notarization. This is finding 35. Did not comply with the notarization, but does not find that the evidence used rise to the level of fraud on the court. That's significant. In addition, he stated on the record, I don't have any reason to discredit Tyler Forey's purported belief. This is at 2643 to 44, which Mr. Hertz cited, but he didn't quote this. I don't have any reason to discredit Tyler Forey's purported belief or the supposed instruction to him that he was okay taking the pictures. And there was no substantive revision to those affidavits.
Could you please respond to Mr. Hertz's assertion that your clients had ample opportunity through the rehearing and evidentiary process to put on the evidence that you're complaining you didn't have a chance to put on?
That position was expressly rejected in the Oltcheck case at star 2 of the opinion.
I'm asking specifically about this particular trial, Judge, because you know that the 50 CA doesn't bind us, right?
I know it doesn't bind you. However, it is persuasive. And what's persuasive about it is that a rehearing or reconsideration is not an evidentiary proceeding. It's a matter of argument on the law, not an evidentiary proceeding. So no one was taking evidence at a motion for rehearing or reconsideration. That's the problem with it. It is not an opportunity to come in and address the issues on an evidentiary basis. That's why it's wrong. And that's why, and by the way, there's no notice at all. It's my clients asking the court to retract its decision based upon an error of law. And so that's not an evidentiary hearing. What I wanted to also say, I think I have 50 seconds left. The court did not make specific findings as to the bad faith conduct or alleged bad faith conduct of each of the defendants below. It was required to do so. The failure to do so requires reversal. And in fact, on 7 of the appellants with regard to the affidavits, the court did not find any bad faith. On 6 of the appellants with respect to the answer, the court found that they properly answered. And with respect to Danielle Forey on the answer, the court failed to find that she acted egregiously or in bad faith. Thank you, Your Honor. Your Honors.
Thank you, gentlemen. I apologize for the technology issues. You all asked for a remote OA and we indulged it. Let's all agree it's not the superior form of the medium. Hope everybody has a good day.
Thank you.